Zero FIR. FIR, First Information Report. So, Zero FIR under Criminal Procedure Code 1973. What is the Zero FIR? What is the concept of Zero FIR? The concept of Zero FIR is new. Zero FIR has not been mentioned anywhere in CRPC. In CRPC, you will not find the word Zero FIR. Nowhere it is mentioned. Not only in the CRPC, even any other central statute or legislation have also speaks about Zero FIR. Then when it comes, where it is? It was introduced in the Criminal Law Amendment Act 2013 on the recommendation of Justice Verma Committee. According to the committee report, the Ministry of Home Affairs issued an advisory to all the police stations. What is the advisory issued by this Ministry of Home Affairs? What is the direction given to the police stations? To lodge FIRs irrespective of the territorial jurisdiction and transfer FIR as per section 170 of CRPC to the stations having jurisdiction. What is the purpose of registering FIR? The purpose of registering FIR is to obtain information regarding any crime as early as possible. So if any person having the knowledge regarding the commission of an offense, he must give an information to the nearest police station. Then, on receiving that information, the police officer immediately, without wasting the time, start the investigation, collect the evidence before they can be tampered with. And the police officer also apprehends and arrests the accused persons if required. So this is the purpose of FIR. Immediately, the information given to the police officer regarding the commission of a cognizable offense, if any person gives that information to the police officer, immediately the police officer will start the investigation. So these FIRs are recorded in a register specifically mentioned for that purpose in every police station. Every police station, there was some register. So the FIRs will be recorded in that register. And the police officer will give a serial number to it, will assign a number to the FIR. Generally, people are not aware of jurisdictional procedures. Every police station has limit, local limits, local area within which within that limit the police has exercised its powers. Whatever the offences have been committed within the limitations of its police station, within the limits of its police station, the police officer has to investigate the case. Generally, we used to call as one town police station, two town police station. These jurisdictional procedures, what is the jurisdiction of the police? People are not aware of it. So, what they will do, the moment they know that the offense has been committed, they will approach to the nearest police station and give the information. And it is the police, the officer has to ascertain whether the offense is committed within its jurisdiction or not. If the police decides that the offense is not committed within the jurisdiction, he refuses to record the FIR. And the people are turned away from the police station on the grounds of jurisdiction. What they have to do, they have again go to the other police station. The police refuses to record the FIR saying that the offense is not committed in his jurisdiction. Again, he has to go to the other police station. So, if they are made to run from one police station to other police station, what is the result? The people get frustrated and the purpose cannot be achieved. So, to achieve the purpose, this Zero FIR was introduced. To achieve the purpose, this Zero FIR was introduced. So it says If the information is regarding some crime committed at a place that is not covered within the jurisdiction of that particular police station, that offense has not been committed in the particular police station, but still the police officer has to record that information and refer to as a zero FIR. So zero FIR refers to a FIR that is registered irrespective of the area where the offense is committed. Now, wherever the offense is committed, if any person comes and gives information regarding the commission of an offense, the police officer must record the FIR. So, a zero FIR can filed in any police station. Now the FIR can be filed in any police station, and such type of FIR is called as a zero FIR. Whether the offense is committed within the jurisdiction or not is all now not necessary. Once if any person knows regarding the commission of an offense, he will give an information to the any police station, and the police officer has to record the FIR. The scope of this provision would be similar to section 154, which allows filing FIR for any cognizable offense. Zero FIR. Zero FIR is jurisdiction free FIR. Zero FIR is jurisdiction free FIR. Zero FIR does not bear the serial number, but the regular FIRs. That is, what is the regular FIR? So that is, if a person gives an information regarding the commission of an offense to the police station and the offense is committed within its jurisdiction, then the police officer record the FIR, register the FIR, and they will assign a serial number. But in case of information given to the police station where the offense is not committed within its purview, within its jurisdiction, then the police officer records the FIR, assign a zero number, and assign a zero number. So therefore, the regular FIR, because it is registered by the police station having the jurisdiction, the police officer will give a serial number. But in the zero FIR, the FIR is recorded by a police officer, but the offense is not committed within its jurisdiction. So he will not give the serial number, he will give only the number 0. So the concept of zero FIR is based on the establishment of jurisdiction-free FIR. The police in such a case can no longer claim that they have no jurisdiction. So now the police officer has no right to say that the offense is not committed within the jurisdiction. So he cannot exercise his powers. He cannot investigate. So he cannot record the FIR. These are all now is not possible. He cannot claim that they have no jurisdiction. So this puts a legal obligation on the police to begin investigation. What is the procedure? Under zero FIR, regardless of the area where the crime was committed, wherever the crime is committed, whether it is committed within its jurisdiction or not, the officer in charge is ought to register the crime under zero number. So the officer in charge of the police station is ought to register the crime and give a zero number. Then according to section 170, the 170 authorizes the police officer to conduct a preliminary inquiry and record the statement of the persons, and also he can record any other necessary information, etc. After that, after gathering sufficient evidence and material, if he ensures that that is a cognizable offense, that the offense committed is a cognizable offense, then he has to. So that means if a person comes to the police station and give an information regarding the commission of an offense, that offense must be a cognizable offense. Then only the police officer will record the FIR. Because the police officer will have a powers only in the cognizable cases. Without getting orders from the magistrate, he will investigate the case, collect the evidence, record the statement of the persons, arrest the accused persons, and after the completion, the charge sheet or the police report will be submitted to the court. So in cognizable cases, the police have enormous powers. So only the FIRs are also registered, FIR also registered only in case of cognizable offences. So you have to ensure whether the information given by the person is the commission of a cognizable offence or not. And if it is a cognizable offence, he has to register the FIR and then give a. If it is not within the jurisdiction, 0. If it is within the jurisdiction, he has to give a serial number. Then a duplicate copy is given to the informant. The person who gave the information to a duplicate copy is to be issued to him at free of cost. The same letter, the same has to be transferred to the concerned police station. Once the Zero FIR is received by the appropriate police station, then that officer in charge of the police station will assign a serial number and it gets converted into regular FIR. But before filing an FIR, it is very important to know whether the offense is a cognizable or non-cognizable. Again, I am repeating, the FIRs are registered or recorded by the police officer only if the offense committed is a cognizable offense. Suppose if the information given by the person is a non-cognizable offense, in non-cognizable offenses, the police officer has no power to investigate the case. And the magistrate, after receiving the non-cognizable offense, a complaint regarding the non-cognizable offense, that is the magistrate, after receiving a complaint regarding the non-cognizable offense, if the magistrate requires any information, he may order the police officer to collect that evidence or to investigate the case. Then the police officer, after receiving orders from the magistrate, then only he will investigate the non-cognizable case. Otherwise, in non-cognizable cases, the police officer has no power. So non-cognizable cases will not be registered FIR and he will not proceed to the investigation. Suppose if the person comes to the police because the people doesn't know what is a cognizable offense and what is a non-cognizable offense. If a person knows that an offense has been committed, he will give the information to the police officer. And it is a police officer has to ensure whether it is a cognizable offense or a non-cognizable offense. If it is a cognizable offense, he will record the FIR and proceed investigation on his own. But if it is a non-cognizable offense, he will keep the information in a book, which is termed as a general diary, and then the matter is reported to the magistrate. So the same is the case even in the Zero FIR. FIRs are filed in the police station. How they will give? And information may be given either oral or in writing. Suppose if the information is given orally by the informant, then it must be reduced into writing. After writing, it has to be read over to the informant. If the informant says any additions or deletions, that has to be done by the police officer, and finally it should be signed by the informant and then registered in the book as the directions of the state government, that is a general diary, and then a duplicate copy will be given to the informant at the free of cost. There are some instances that FIR was filed through email and telephonic means of communication. Online FIR is also prevalent. FIR can be lodged by anyone, anywhere at an online platform. So there is no restriction. From anywhere you can file an FIR. No necessary to go to the police station having the jurisdiction. Even the travelers who become either the victim or if they have witnesses any of the cognizable offense, they can lodge a zero FIR through email or any other social media. So now the FIR can be filed to any police station. You can you can file the FIR from any place, from anywhere, either from person or through email or any other social media. What is the legal provisions? If the police officer refuses to register zero FIR, what we have to do? If the police officer refuses or denies to register a zero FIR, then the aggrieved person can write to the superintendent of police. The aggrieved person has to write to the superintendent of police. And still, if it does not work, then he can send a complaint to the magistrate. And a new section, section 166 AC, was added in the Indian Penal Code. So this section 166 AC says, if any public servant fails to record any information given to him under subsection 1 of section 154 of the Code of Criminal Procedure 1973 in relation to cognizable offense, punishable under sections 326A, 326B, 354, 354B, 370, 370A, 376, 376A, 376AB, 376B, 376C, 376D, 376DA, 376DB, 376E, and section 509. Then the police officer shall be punished with rigorous imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years and shall also liable to be fined. So this was introduced in the Criminal Amendment Act 2018. Further, disciplinary action will be taken against erring the officers who do not register or who refuse to register the FIR if the information received by him discloses a cognizable offense. So here there are two types of punishments, actually three varieties. Suppose if he refuses to register an FIR, a complaint is to be given in writing to the superintendent of police. If it does not work, then you can give a complaint to the magistrate. This is one type of action. Second, if any person gives information regarding the cognizable offense, which is punishable, that cognizable offense which is punishable, any one of this list, and if the police officer refuses to register, so if the police officer refuses to register any one of these offenses, all are cognizable offenses only. If any person gives an information regarding any one of these offenses, the police officer refuses to register the FIR, then the police officer is liable to be punishable with imprisonment for a term, rigorous imprisonment, not a simple imprisonment. The police officer is liable to be punished with rigorous imprisonment for a term not less than 6 months, but which may extend to 2 years and shall also be liable to fine. This is the second mode if the police officer. Third, if the person gives an information regarding the cognizable offense other than this list, then the disciplinary action will be taken against the police officer. So there are three varieties. One is you have to give a complaint to the superintendent of the police. There also, if it does not work, then you have to give a complaint to the magistrate. This is one way of taking an action against the police officer if he refuses to register the offense. Second is, if where the person gives the information regarding the cognizable offense which falls in any one of these offenses, and if the police officer refuses to register, then he is liable to be punishable with rigorous imprisonment for a term not less than 6 months, but which may extend to 2 years and shall also be liable to fine. And the third category, The person came to give an information regarding the cognizable offense, but other than these offenses, other cognizable offenses. Then, if he refuses to register the FIR, disciplinary action can be taken. So these are the actions can be taken to the police officer against the police officer if he refuses to register the FIR. In 2008, the Delhi High Court in Bimal Rawal and others versus NCT of Delhi held that if the information given to the police discloses the commission of a cognizable offense, the police cannot refuse to register the FIR. After registering, they are supposed to start an investigation immediately. If during the course of investigation they realize that the crime was committed in some other jurisdiction, then they should transfer the case to the police station having a jurisdiction. Then that police officer will investigate the crime. But however, if it is evident at the time of registration itself that the crime was committed was a cognizable offense, that the crime was committed in some other jurisdiction, then they should register the information as a Zero FIR and immediately transfer the same to appropriate police station having jurisdiction over that matter. The Honorable Supreme Court in Lalit Kumar versus the state also held that any information which amounts to a cognizable offense, it is mandatory to register as FIR by the police under section 154 CRPC. There are certain advantages of Zero FIR. What are the advantages? It avoids delay and any other kind of disruptions, enables the police to conduct the investigation in a speedy manner, to make the police bound to take jurisdiction, to make sure that investigation is done properly, to inspiring confidence among the general public. Now, presently, the Zero FIR is mandatory. It is registered by the police, but still, most of the police officials are not aware of it. Still, they are denying to register the FIR on the grounds of jurisdiction. So this is the Zero FIR. Now it is very easy. FIR can be filed anywhere from any place, either by post or by telephone or by email or any other social media.